Well, guys, we've been at this for a long time, but we finally reached the end here with the judge ruling on Blake Lively's motion for fees against Justin Baldoni. As we know, he had granted her 47.1 damages related to the one claim in Justin Baldoni's countersuit. And many people thought that she would get in the millions of dollars because she made a request for a ridiculous amount of $8 million related to one claim, trying to snake in a lot of her lawsuits, which she, was not granted fees for because she settled that lawsuit for nothing. But I wasn't sold on that. I said I don't think so. I think I said 500,000. If you guys were watching or you can pull it up, let me know what I said when Omar and I were discussing this fee motion, because I'm pretty sure he was telling me somewhere in the seven figures, and I was like, I think it's gonna be 500,000 or less. And don't worry, I texted him and gloated before I started to stream, but it's the middle of his workday, so he's not with me right now. After hundreds of hours of streaming on this case and me growing out my hair to a gender appropriate length, almost, it's been a lot has changed since we started doing this. I was just a very small YouTube channel who had only ever talked about one case. This was the second thing I ever worked on, and it was something that I really felt passionate about. Yeah, so this being the last thing we'll ever get out of this case is kind of bittersweet, I guess, but I'm really happy that, people get to move on with their lives and they don't have to deal with the pain of these lawsuits anymore. I know that must have been really hard for Justin and his family, for Jamie and his family, and for everyone else. I can't give you full details yet, but next week, on September 2nd, I have something pretty cool planned. So look out on that date, probably at nighttime, where I'll have something for you guys that you're really going to like. But no spoilers. All right, I'm going to go through the judge's ruling with you guys. He awarded her 5% of what she asked for. And it was around $400,000, a little over that. So let me move this here. Okay, I'm going to zoom in so you guys can read as well. Hopefully you can see that. Okay, so you can read along if you want to. Give me 1 second here. All right. The two cases involve the film It Ends With Us and the contentious fallout between the film's two co-stars, Blake Lively and Justin Baldoni. Blake Lively, defendant in case that was the Wayfair lawsuit, now moves for an award of attorney's fees and costs pursuant to 47.1. For the following reasons, the motion is granted in part and denied in part. And I know everybody gets like all flustered when they're like, oh my God, he loves to grant in part, deny in part. That's not uncommon. I think we know this by now, right? That's not uncommon. Angela says it ends with 5%. Guys, let me know if my microphone is working okay as well, because I was having some audio problems. So if something's wrong, just let me know. Heidi Heather 100, thank you for the 250 joules. I appreciate that. All right, let's keep going. The court has previously outlined the background of this dispute at length. Familiarity with the prior proceedings is presumed, right? Lively and Baldoni have waged fierce battle against each other in court. Lively initiated the legal dispute by filing an administrative complaint before the California Civil Rights Department on December 20th, accusing Baldoni and his co-defendants, collectively the Wayfair parties, of sexual harassment and retaliation in connection with conduct on the set of the film and related to the marketing of the film. Now, if you're listening to this, you probably seen me talk about this case before, and you probably know a lot about this case at this point. But on the off chance that you're new here, Blake Lively's sexual harassment claims were dismissed by the judge, all of them. So she had some remaining complaints against the corporate entities, which she settled for $0. Okay. Lively followed that administrative complaint with a lawsuit filed in this court on December 31st, leveling charges of sexual harassment, retaliation, breach of contract, intentional infliction of emotional distress, negligent infliction of emotional distress, and false light invasion of privacy against Baldoni and the Wayfair parties. So she did end up dropping those emotional distress claims voluntarily as well, if you guys don't remember that. The Wayfair parties responded several weeks later with a lawsuit against Lively and her husband, Ryan Reynolds, as well as against her publicist, Leslie Sloan, and Vision PR. The complaint in the Wayfair action contained causes of action for civil extortion, defamation, false light invasion of privacy, breach of the implied covenant of good faith and fair dealing, intentional interference with contractual relations, intentional interference with prospective economic advantage, and negligent interference with prospective economic advantage. On January 31st, they filed their first amended complaint. It added claims against the New York Times for defamation, false light invasion of privacy, promissory fraud, and breach of an implied, in fact, contract. Otherwise, it contained the same causes of action against Lively, Reynolds, Sloan, and Vision. Okay. On June 9th, the court granted the motion of Lively and the other defendants to dismiss the first amended complaint in the Wayfair action, giving the Wayfair parties leave only to amend their tortious interference with contract and breach of implied covenant claims by June 23rd. The Wayfair parties did not file a further amended complaint, and they won't be doing that. I don't know if you guys remember, but the settlement, as part of the settlement, they agreed they will not be appealing the dismissal of their lawsuit. So that's not going to happen. This is done at this point. Like, this is it. I know, and we keep saying that because it's like they settled the lawsuit. Oh, it's over. No, now they're doing fees. Oh, it's over. No. They're done now. And some people thought there was going to be a hearing on this fee issue. I was like, please no, God, I'm so tired of of this back and forth. But there was no hearing. This is the final ruling. So, one second. Okay. Hey, Sarah, what's up? Somebody says 5% is too much. I mean, I'm sure nobody's thrilled that they have to pay anything, but $400K when you ask for $8 million is kind of hilarious. There was no way he was not going to give her anything, right? Because he already granted the motion for the 47.1 damages. But I'm sure there's going to be a crazy amount of spin on this, I'm sure, like there always is. That used to do my head in, but now I'm just kind of rolling my eyes at her attorneys and their PR stuff. It's like, obviously this didn't go well for you, so I'm not taking it to heart. You know what I mean? Okay. On September 8th, Lively moved for attorney's fees, treble damages, and punitive damages under California Civil Code 47.1. He denied the treble and punitive damages, so he only granted the attorney's fees related to that claim, the defamation claim. And that was on June 12th this year. I'm going to kind of not read this word for word. The court determined she was entitled to fees and costs in connection with the lawsuit alleging claims of defamation. In that same order, the court determined she was not entitled to compensatory or punitive damages. Okay. Then they submitted their papers regarding the appropriate measure of fees. Lively sought $8,035,040.88 in fees and costs, including, and this is about 7.5 in attorney's fees and costs in the amount of, and costs in the amount of a little over 500,000. The Wayfair parties argued that Lively's request is so inflated that the court should deny it altogether, and that at a minimum, the court should substantially reduce Lively's request, using as a benchmark the $181,622 the New York Times sought in related litigation as fees and costs for defending against a related claim brought against it for defamation. Okay. Somebody says, so that leaves her with $7 million to pay herself. I'm pretty sure she's paying a lot more than that. Like the ask was inflated, but I'm pretty sure she's paying a lot more than that. So that, that's not, this is not a victory. And I'm sure they'll try to spin it that way. I can see it now. The Blake Lively recovers $400,000 for women's rights or some crazy bullshit like that. I mean, this was nothing but petty nonsense because she thought she was better than her director and she didn't like him. Like, this is just dumb. It's just dumb. Oh, well. Page 6 headline is very appropriate. It says, Anav JB, Blake Lively dealt humiliating blow after requesting $8 million payout from Justin Baldoni. Yeah, right. Okay. The scope of Lively's entitlement to fees. The parties spar at the outset on the reasonable fees and costs for which Lively is entitled to reimbursement. Lively claims she's entitled to reimbursement for all of the attorney's fees and costs she incurred in the litigation in which the defamation claim was asserted, including the fees and costs incurred in furtherance of that recovery. To that end, Lively seeks reimbursement both for all of the fees incurred on the motion to dismiss the First Amendment complaint, but also all work associated and intertwined with the Lively action until June 23rd, the date by which the Wayfarer parties could amend the FAC. And some of that, like, when I was reading over what they were asking for to get paid for, some of it was related to the stupid content creator subpoenas they sent out. And if you're new here, Blake Lively tried to subpoena my YouTube channel, asking for weird personal information back in, God, what was it, July 25? It's been a little over a year. That was a massive fail. So somebody says her birthday was yesterday, but Blake demands an entire birthday month. Listen, man, $400,000 on your birthday, good for most people, right? I would take it, but not for her, I guess. Okay. So they asked for to be paid for stuff that was like very clearly not related to defending against the defamation claim, which is obviously why the amount is far short of what she asked for here. Okay. The Wayfarer parties claim that Lively is entitled only to the reasonable fees and costs necessary to defend against the defamation claim. The Wayfarer parties have the better of the argument. California courts look in the first instance to the words of a statute in construing its meaning. If the language permits more than one reasonable interpretation, however, the court looks to a variety of extrinsic aids, including the ostensible objects to be achieved, the evils to be remedied, the legislative history, public policy, contemporaneous administrative construction, and the statutory scheme of which the state statute is a part. The language of 47.1 is ambiguous. It provides that a prevailing defendant in any defamation action brought against that defendant for making a communication without malice that is privileged under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation. The statute does not speak directly to whether litigation refers to that portion of the case that contains claims for defamation or whether it extends to the entire litigation, including unrelated claims against the defendant. So they were trying to argue that it applies to the litigation as a whole, like the entire case, all the claims. But the Wayfarer parties said, no, just the defamation claim. He finds that their argument is more, it's a better argument. I remember they were talking about how she was kind of trying to skirt the system by settling her case and making it so the Wayfarer parties did not get a jury trial and then trying to have them pay for things related to that case that she settled for $0. That was frustrating. And then this issue of malice, nobody ever determined if there was malice or not. This did not go to trial. Obviously, this was dismissed early on, the Wayfarer party's complaint. Oh, hey, Omar, what's up? So, you know, as far as this, like, people will try to make the argument that she clearly made it in good faith. The thing is, they never determined that. That was never decided on. That was never argued, even in front of the courts or in front of a jury. So, you know, it is what it is. All right. Okay. An examination of the evils to which the California legislature addressed itself in 47.1, as well as considerations of public policy, suggest that the defendant is entitled to reimbursement only for those fees and costs incurred in defending against the defamation claim. Okay. An examination of the evils. I sound like I feel like I'm reading a sermon. Sorry. Okay. As the court previously observed in passing Section 47.1, the California legislature intended to provide a measure of protection for the speech uttered by victims of sexual assault. The law begins with the declaration that a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is privileged under Section 47. The California legislature intended to deter a form of slap lawsuit, which the legislature found was increasingly being used as a weapon to threaten, silence, intimidate, and dissuade survivors of sexual assault, harassment, and discrimination from speaking out against their abusers and exposing predators. So this, like, her getting these fees paid for based on having the defamation claim dismissed and no determination of whether or not there was malice in her complaint. It's frustrating because she uses this language to try to act like she was a martyr for some sort of martyr for women or some sort of crusader for women in the workplace. It's like, that's obviously not what you were doing at all. Oops. Sorry, let me turn that off. So I mean, she can parade herself around as some sort of advocate if she wants to. I don't buy it. What has she done to kind of make the workplace safer for women other than promote herself? There was no determination that she was sexually harassed. There was definitely no determination that she was ever assaulted. That wasn't even really alleged. So it's frustrating because she can apply this language to what happened here, even though it doesn't really apply. So let's see. Oh, Babcock's going to put this on the Texas docket. Yeah, sure. All right. Dima, thank you for the JOD 100. So I don't know what JOD is. I think is it Jordanian? I'm not sure. Hey, Lauren, you've been on this trial from the jump, and I just want to say thanks for all the work, time, and money you put in. This is such good news. Congrats to everyone who's been fighting for the truth. Love you. Oh, thank you very much. I appreciate that. And I know I've seen you around a lot, so thank you. I appreciate you. That's awesome. All right. Okay. Slap lawsuit. It also intended to help take the burden off survivors by providing reasonable attorney's fees and damages if they successfully defend themselves against meritless lawsuits. There's nothing in the law or the legislative history that indicates that the California legislature intended to award a defendant accused of a range of tortious conduct other than a slap lawsuit all of her fees and costs in defending against that conduct simply because the person who is the target of that conduct has included in his or her lawsuit a claim for defamation. The facts of this case illustrate the point. Defamation was one of many complaints made by the Wayfarer parties against Lively, her husband, and her publicist. The Wayfarer parties also alleged that Lively engaged in civil extortion in violation of California law when she, 1, refused to return to production unless they agreed to her return demands, which we've, heard about that endlessly, that list that she forced them to sign. 2, threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfarer parties agreed to co-fund a screening of her version of the film, eventually release that version, and grant her a producer credit and support in seeking the PGA designation. 3, threatened to boycott the premiere unless Baldoni was excluded. And 4, threatened to attack Wayfarer in the press if it did not take the blame for problems during filming. Yeah, she was hellish. Okay. And this is 21 pages. Some of this stuff we'll probably skim over because I do have to get back to work pretty soon. But, and we know all this already, but I'm going to read as much of it as I can. I just have to lock in. Sorry. Okay. Let's see. They further allege that Lively with Reynolds intentionally interfered with Baldoni's relationship with his talent agency by making threats to it to drop Baldoni. The court dismissed the civil extortion claim only after an extended discussion in which it took issue with a decision by a federal district court in California. It dismissed the claims for breach of the implied covenant and intentional interference with contract without prejudice. Those claims were not pursued only because Baldoni decided not to pursue them. Lively has given no reason why she should be entitled to her fees and costs in defending against each of those claims, simply because the Wayfarer parties also chose to sue her on a claim that she was making false allegations of sexual harassment against them. nor has she provided a reason why she's entitled to an attorney's fees or costs after June 9th, the date when the court dismissed the Wayfarer party's defamation claim with prejudice. So she was asking for money or on things related to all the way up to like the settlement and after. So that was bizarre. Okay. The federal rules allow a plaintiff to state in one complaint as many separate claims as it has. The rules thus contemplate an expansive definition of case, including all claims that the party has against a particular opponent falling within federal jurisdiction. If Lively's interpretation of the litigation in Section 47.1 were adopted, it could not be limited to claims that related to the defamation claim. It would extend to all fees and costs incurred in the entire litigation, regardless whether the claims had any relation to the defamation claim. Such an interpretation would extend far beyond the goals that California legislature was intending to accomplish in enacting Section 47.1. So what she was asking for is like far beyond the scope of what this law is supposed to do. So, okay. This conclusion is consistent with California law. The California courts have held that when a cause of action for which attorney's fees are provided by statute is joined with other causes of action for which attorney's fees are not permitted, the prevailing party may recover only on the statutory cause of action. Okay. That principle has been applied to the California Automobile Sales Finance Act. This is what I'm going to skim over. I don't need to do that. There is no reason to believe that the California courts would apply a different interpretation to California Civil Code, Section 47.1. The footnote here says Lively notes that California's anti-SLAPP statute provides for an award of attorney's fees and costs to the prevailing defendant only on a special motion to strike. Okay. But the court need not interpret Section 47.1 to give the defendant who prevails on a defamation claim an entitlement to attorney's fees on all claims against her to ascribe different meaning to the two statutes. Under California law, a party is not entitled to fees under the anti-SLAPP statute unless she has made a motion to strike and prevailed on it. By contrast, under Section 47.1, the defendant need only have prevailed on a defamation claim that was based on a statement that is privileged under 47.1. Okay. Lively seeks, and it's a little over $8 million in fees and costs, comprises $7.5 million in attorney's fees and costs and about $500,000. $7.5 million in attorney's fees and costs, and the amount of is $539,000. Okay. Under California law, a trial court assessing attorney's fees begins with a lodestar figure based on a compilation of the time spent and reasonable hourly compensation of each attorney involved in the case. The court calculates the lodestar by multiplying the number of hours reasonably expended by the reasonable hourly rate prevailing in the community for similar work. Two law firms, and we'll just call them Mannett and Wilkie, represented Lively in this action. Lively has submitted evidence that her attorneys from Wilkie charged her at rates ranging from $1,551 to $2,795 for the partners assigned to the case, and $1,275 to $1,573 for two of the associates. Lawsuits are not cheap, man. Like, you do not want to sue somebody if you're not, like, you can never be sure you're going to win, but if you don't have a really good case, don't do it. So I see people saying, why doesn't this person sue her? Why doesn't this person sue her? I'm like, I don't want any piece of that. Even if, like, people ask, like, why don't the content creators sue her? Like, even if there was a case to be made, which I don't really think there is, because we were non-parties who were subpoenaed and they were, ultimately withdrawn. So there's no damages really to go for. I wouldn't want any piece of that. Like, I'm not paying that. Are you crazy? Like, there's no way. Imagine paying that much money just to be stressed out over Conspiracy Barbie. Like, I'm not doing that. No way. That sounds miserable. All right. The median charge for all partners was $1,650, and for all associates, $1,225. Wilkie provided Lively a discount of 15%. Oh, how generous. Off its standard hourly rates. The partners from Mannett charged Lively discounted fees ranging from a rate of $1,161 to $1,287 and $1,026 to $1,138 for the most senior partners, to effective rates of $1,008 to $1,120.50 and $1,044 to $1,161 for the more junior partners. Okay. An hourly rate is reasonable when it is within the range of reasonable rates charged by a judicially awarded comparable attorneys for comparable work. Okay. All right. A billing rate that is the usual rate an attorney charges for his or her services is evidence that the rate approximates the market rate. The actual billing arrangement certainly provides a strong indication of what private parties believe is the reasonable fee to be awarded. The fact that a paying client was willing to pay and in fact paid a certain amount to litigate a case is strong evidence that the fee was reasonable. Okay. I'm going to skim through some of this. At the same time, the prevailing defendant is entitled to reimbursement only for reasonable attorney's fees. The prevailing defendant cannot burden the plaintiff with an exorbitant fee arrangement. Counsel's rates were not unreasonable. The case as a whole presented substantial financial and reputational risks for all parties involved. It also involved complex legal issues. It was extremely well litigated. The rates are not outside the range of reasonableness in the community for the best lawyers handling highly complicated and high-stakes litigation. Lively seeks attorney's fees for 82 timekeepers, including 53 from Wilkie and 29 from Manet. But she includes biographical information, title, and billing rate information for only 11 timekeepers. The court has no basis to evaluate the fee request for the remaining timekeepers and therefore denies it. Okay. Includes biographical information, title, and billing rate for only 11 timekeepers. So they have no basis to evaluate for the remaining time. So like what? 11 out of the 82? I couldn't remember. Why did they only include that for 11 of them? The court has no basis to evaluate the fee request for the remaining timekeepers and denies it. Okay, cool. The number of hours for which Lively seeks reimbursement is unreasonable. Lively has submitted the declaration of a purported attorney fee expert who has reviewed the billing records. Lively has not submitted the invoices themselves. The analyst claims that the two firms billed $2.2 million for motion practice in the Wayfair action, including the motion to dismiss, a Rule 11 sanctions motion, and the Section 47.1 motion. She also claims the two firms billed her for work associated and intertwined with both actions, including discovery and fact-gathering exercises in the amount of $5.2 million through June 23rd, 2025, which is insane. One sec. Okay. Give me 1 second here. Oh, Dima, thank you for the 20 gifted memberships. I appreciate that. That's awesome. Kelly511, thank you for the 100 jewels. Thank you so much. And Dima, thank you for the JOD 50. Hey, Lauren, Elsrich wants you to check your phone. What's on my phone? Hang on. Can y'all stop yelling at me? Is my mic okay? I see somebody saying my sound is cutting in and out. Can you please let me know if that's... how much longer... Don't want to. Yeah, LC. I will send. I'm not going to be doing this much longer because I got to get back to work. So I will send people to you. Can you send me another text when you have your thing set up so that I can set it to the redirect? Because I have to rush through so that I, because I only get an hour for lunch. So otherwise, I would, obviously love to have a party with you guys, but yeah, I can't. All right. Sorry, I didn't see your message until everyone started yelling at me in the chat, which I didn't see until now. Someone tell Lorna to beat her ass. Well, it's big. You got your work cut out for you. So, just saying. All right. Why don't we continue here? Okay. As an initial matter, Lively is entitled to reimbursement for the reasonable attorney's fees incurred in briefing a portion, but not all, of the motion to dismiss and all of the Section 47.1 motion. Well, let me just text her back. Just in case she didn't hear what I just said. I don't know if she's still in the chat or if she's on her way to beat my ass. Okay. Cool. She's not entitled to reimbursement for any of the costs of the Rule 11 motion. The Rule 11 sanctions motion, I was like, why are you trying to include this? Lively filed a 36-page memorandum of law in support of the motion to dismiss, in which she argued that the complaint and the Wayfair action failed to identify the specific defamatory statements by Lively. Certain statements were outside of the statute of limitations. Lively's statements were protected by a number of privileges under California law, and the first admitted complaint failed to allege actual malice. So they had, I don't know if you guys can hear that, but it's trash day, and so they're picking up my trash can outside. They'll have to pick me up next time. But that's what that loud noise is, in case you can hear it. Okay. She also filed a 16-page reply memorandum of law. The costs she incurred for those filings were incurred in defense of the defamation action, but the category of motion practice is overexpansive and includes work for which Lively is not entitled to an award of attorney's fees. The two law firms also represented Reynolds, who filed an entirely separate motion to dismiss, supported by a 29-page memorandum of law. Lively is not entitled to reimbursement for the costs of preparing and filing that motion. And why would she be? Ryan Reynolds never alleged anything that would fall under 47.1. Panic Planet. How much? 400,000? Not even. It's under 500,000. Yes. Okay. Right. Also to the Rule 11 sanctions motions, it was directed to claims asserted by persons other than Baldoni against Lively and Reynolds for civil extortion, defamation, and intentional interference with contract and breach of an implied covenant. The motion was directed solely to the defamation claim against Reynolds. It sought no sanctions for the Wayfair party's defamation claim against Lively. Okay. The court granted in part and denied in part the Rule 11 sanctions motion. Importantly, the court denied Lively's request for attorney's fees as a Rule 11 sanction. Okay. Lively thus is not entitled to reimbursement for the work on that motion. Lively is entitled to reasonable attorney's fees for her motion directed to whether she was entitled to fees under section 47.1. Okay. There is no doubt that Lively is entitled to reimbursement for some of the fact gathering and discovery processes. And then he's quoting here, fees need not be apportioned when incurred for representation of an issue common to both a cause of action for which fees are permitted and one for which they are not. Okay. All expenses incurred on the common issues qualify for an award. Discovery against Baldoni in the Wayfair action, unlike discovery against the New York Times, was not stayed. Work devoted to discovery on Lively's sexual harassment claim would have been intertwined with the work necessary to defend against the defamation claim. But Lively's blunderbuss approach, blunderbuss, I've never heard that word before. Hold on. A blunderbuss is an early muzzle-loading firearm with a short, large caliber smoothbore barrel and a flared muzzle. Okay, so I was imagining a bus, like an actual bus, just like knocking shit over, blundering. You know what I mean? Personally, I like my definition better. So, Lala4499, thank you for the 100 joules. I appreciate that. I'm gonna start using that in like regular conversation. Blunderbuss. Okay. Lively's blunderbuss approach leaves the court no way to determine precisely how many hours were reasonably incurred on common issues. Yeah, that was predictable. Her fee motion was just I don't know. It kind of felt like somebody was throwing mashed potatoes at a wall. Why would you be doing that? Why would you be doing any of this? All right. Moreover, the Wayfair parties have identified a series of flaws in the records that are illustrative of a broader discrepancy and deficiency in the fee schedule. Okay. Right. First, the billing records contain entries for internal communications that are often vaguely described and do not identify the issues discussed, work performed, or whether the meeting pertained to defending the defamation claim or the broader litigation. So he's giving examples here. Entry for legal strategy calls, confer with team work streams, research related to types of relevant cases, correspond with team refiling. Okay. Internal communications may represent reasonable collaboration, but where extensive, courts may reduce fee awards for hours billed for internal, interoffice, or intra-office communications or conferences. So are we not going to have them pay for the Wayfarer Summit, the Lively v. Wayfarer Summit, or whatever crap that was? Second, the records include entries that are partially redacted, which makes it difficult to determine the full scope of the work performed. For example, one entry bills time to revise legal memo into XX, and another bills time for analyze and revise final draft of legal memo addressing XX. Okay. See also, participate in strategy telephone conference and XX in preparation for drafting legal memo on XX. All right, now you're just confusing me, so I'm going to skim. In the federal context, a district court has an obligation to deny a fee request where billing records are so heavily redacted they do not provide sufficient information for the court to judge the reasonableness of the fee request. And that was definitely the case here. I remember a lot of people talking about that. Okay. We're going to skim here. Relatedly, many entries are vague and render it difficult to determine what work was performed, on what motion, and in which action. There's a footnote here that says not all redaction in Lively's billing submission are improper or warrant a fee reduction. Redactions of the name of individuals on strategy calls and redactions that conceal potential legal strategies do not, in and of themselves, unreasonably obscure the fee request. Okay. The vagueness at issue here stems in part from the need for the court to assess whether billing entries pertain to the defamation claim, such that recovering attorney's fees for that entry is warranted. Okay. Third, Lively seeks fees for time billed towards media relations, including strategizing media communications and client media appearances. Okay. So, like reviewing the media coverage and strategizing. Okay, advise regarding legal issues related to media statement. Hours spent for media contacts and press conferences are generally not compensable. Federal courts have found the giving of press conferences and performance of other lobbying and public relations work is solely compensable where it is directly and intimately related to the successful representation of a client. Okay, that litigation involves reputational interests is insufficient. Okay. That litigation involves reputational interest is insufficient on its own to render media communications intimately related to clients' representation. Media relations were not integral to defending the defamation claim brought against Lively. Accordingly, time spent on media relations and press coverage is not compensable. So some of this stuff that she was asking for, especially the PR stuff, was like banana Cocoa Puffs. Like, what are you doing, man? Right. Steve, how's it going? Thank you for the 650 joules. I appreciate that, man. Good to see you. All right. Fifth, Lively seeks fees for clerical or administrative work that was billed at attorney rates. Okay. Purely clerical work is not compensable at attorney or paralegal rates. Okay. Sixth, Lively also seeks fees for travel time, but in some entries does not identify the proceeding or other event related to the defense of the defamation claim that required such travel. Courts will award attorney's fees for travel time so long as the amount of time spent traveling is reasonable and the meeting or event to which the attorney is traveling is necessary to the case. Okay. Absent identification of a necessary meeting or event, attorney's fees for travel are not warranted. In such circumstances as present here, where the prevailing party has not made any effort to allocate the fees to the claim on which she prevailed, the California courts will assign a reasonable percentage to the entries or simply cast them aside. The court is also permitted to apply a steep discount where a party has made an outrageously unreasonable demand. If the court were required to award a reasonable fee when an outrageously unreasonable one has been asked for, claimants would be encouraged to make unreasonable demands, knowing that the only unfavorable consequence of such misconduct would be reduction of their fee to what they should have asked in the first place. To discourage such greed, a severe reaction is needful. The New York Times has asked for a reasonable attorney's fees in the amount of about $181,000 in connection with its defense of the defamation claim arising from the same statements. Lively was reasonably required to incur greater fees, including with respect to discovery and the briefing of the Section 47.1 motion. Accordingly, the court awards Lively double the amount sought by the New York Times, or $363,245.40 in attorney's fees. So $363,000 after asking for $7.5 million is that's cute. Maybe she can pay to get her nails done with that. I don't know, dude. Rich people buy stupid stuff. It's expensive. Okay. This is basically she lost 95% of her claim for yeah. Okay. So they gave them twice the New York Times amount. Let's see. And now we're talking about costs because he also gave her, I think it was like $50,000 or plus in costs. Lively's request for litigation costs is governed by Section 1033.5 of the California Code of Civil Procedure. That section provides that filing and motion fees, deposition costs, service costs, ordinary witness fees, and costs of transcripts where ordered by the court are allowable as costs. It also excludes certain categories of litigation expenses from costs. So the following items are not allowable: fees of experts not ordered by the court, investigation expenses in preparing the case for trial, postage, telephone, and photocopying charges, except for exhibits, cost and investigation of jurors or in preparation for voir dire, transcripts of court proceedings not ordered by the court. Okay. It further provides that allowable costs shall be reasonably necessary to the conduct of the litigation rather than merely convenient or beneficial to its preparation, and shall be reasonable in amount, and that items not mentioned in this section and items assessed upon application may be allowed or denied in the court's discretion. Section 47.1 does not expressly authorize costs beyond those allowed under Section 1033.5. Lively's expense analyst provided 3 spreadsheets representing costs incurred by Lively in this action. The spreadsheets include costs for travel, research fees, experts and consultants, office supplies, and filing fees. Among these costs, Lively identifies $173,000 in costs charged by GBX Holdings LLC as incurred exclusively for the purpose of assessing the impact to Ms. Lively's reputation, if any, from the Wayfair action in support of the Section 47.1 motion. Time billed to Wilkie by GBX Holdings LLC included time to research and preserve social media posts, news articles, and TV news materials with mention of defamatory content related to the Section 47.1 claim, and time assembling a Section 47.1 report with such information. This report, while related to Lively's Section 47.1 motion, is fairly categorized as an expert report, the cost of which is not recoverable under California law. Lively additionally seeks $134,000 in research expenses for Westlaw, Lexis, Bloomberg, Pacer, and similar charges. California Court of Appeals has found that legal research falls under the non-recoverable category of investigation expenses. As to Lively's other expenses, those for travel, meals, office supplies, and discovery services, Section 1033.5 does not expressly allow or prohibit recovery for such costs, and those costs accordingly may be awarded or denied in the court's discretion. So are they not going to pay for the DoorDash to the office? These expenses are not explicitly tied to an identified motion, appearance, or aspect of litigation. Where it is not possible to allocate expenses for specific claims, it is appropriate for the court to award a portion of the total expenses. Okay. The court will award costs for $11,000 in travel expenses, identifiably tied to court appearances for the pre-trial conference, and the oral argument on the Section 47.1 motion. The court will further award costs for the $154.80 in transcript filing fees and 1/6 of the expenses for discovery services incurred prior to June 9th, 2025, in the amount of $32,000. In sum, the court awards $44,206.35 in costs. Okay. Lively's request for attorney's fees and costs is granted in part and denied in part. The clerk of court is respectfully directed to enter judgment for Lively in the amount of $363,245.40 in attorney's fees and $44,206.35 in costs. So a little over $400,000. And that's all she wrote, man. Andrew's made up name. Well, hello, that's a nice last name. Thank you for the $5. Appreciate that. Blunderbuss approach. Definitely a clumsy, broad, and unsubtle method trying to solve a problem using force and random scattering rather than precise targeting. Yeah. I'm still thinking of a school bus just like bulldozing over everything, but you know. All right, let me see if Elsie's set up yet. She might be. Guys, don't forget to hit the like button for me. It helps me out a lot. I don't see it. Oh, no, there it is. Shit. Elsie has to turn on her redirect privileges. I don't think she has it on. Well, I don't know. You guys have to let me know what you think about this ruling, whether or not you thought it was fair. I know a lot of people think that she shouldn't have gotten anything. So, but as far as her getting something, because we knew she was probably going to get something, right? What do you think about that? We know she will use hundreds of thousands to death. Yeah. If I can't redirect, I'll just give you guys a link to Elsie, but I don't know. Updates. No, that won't work either. I hit the like button exactly as you just said. Thank you. Appreciate that. The author 47.1 disagrees with paying her. Yeah. I feel like it was fair, all things considered, especially since none of it goes to her. I mean, yeah, she's not really going to see any of that. At least I don't think. Let's see if I can go to, because I'm going to have to go back to work in a second. Somebody said there should be some documents being unsealed and put on the docket soon. We'll go over that as well. But this is the final, this is going to be the last ruling in this case. They're finally done with it. Blake's best birthday ever. Is that what? Okay, that's what she named her stream. Hold on.
Housekeeping.
Real quick. Okay, so you know where it says go upload a video.
I'm gonna send you guys over to LC here and Carol. Her redirect isn't on, so I'm just giving it one more minute to see. Hold on, if I can figure it out.
It is okay. Do you see the on the left hand side?
Yeah, Carol's trying to walk her through it. All right, I'm gonna put the link in the chat as well. You refresh this, see if I can get it to work. That's not what I want. Yeah, both these guys have their freaking redirect turned off. I think the judge wanted this over with before the shocking depositions came out. What shocking depositions? I just started catching back up on this whole universe last night with some of the Able stuff. But I had to take a little break from this case. So every case, every viral case or whatever that I've been seeing lately, there's been so much rabid hatred towards everyone, really. Look at the Nolan Wells case, for example. There's so much hatred towards his family and towards his friends. The Carmelo Anthony case, there's rabid hatred on both sides there. There's this Lindsay Clancy case where there's rabid hatred towards the husband and rabid hatred towards her and rabid hatred towards the family. And it's just exhausting I started thinking, like, man, and this isn't the first time I've had this thought. If you guys have been following along, you know that I have been trying to change up my tone recently, not be so, aggressive or hateful. You know what I mean? Like, I can criticize without being a giant raging douche. And I just thought, I don't want to contribute to what some of these people are putting out into the world, attacking people. So I have to stop that. I have to be better than that. So, I took a little break from this because I know this has been something that has in the past kind of caused me to have an intense reaction. And so, but now now this is done, but I'm still going to follow with Jen's case, of course, against Stephanie Jones, and see how that goes. So, all right. Somebody says not as Conti. Correct. That's kind of what we're going for. Not as Conti. All right. Let me try again and see if they figured that out finally. Oh my God, it's a freaking miracle. She figured it out. Okay. All right, guys. I got to get back to work now. I got only 9 minutes left in my break. So let Carol and Elsie know I said hello. And I will see you guys pretty soon, probably. I know there's some more stuff that's going to be coming out, and we'll go over that together. So I will be on tonight at midnight with Omar to go over the Lindsay Clancy case today. So if you're interested in that, I'll have a link up later. If not, wah. Okay. All right. See you later. Bye.